let's say, a random internet protocol address. That's the address that your computer has when you connect to the internet. And it's random, so you don't know who's behind that number. But if there's a way legally for you to make the connection between the data and the person, for example, going to an internet service provider and asking them to make that connection, well, then you are an identifiable natural person, even if indirectly. And so that would be covered as well. So this concept of personal data covers names, telephone numbers, addresses, emails, but it covers lots of other things as well. And for example, it can cover if you connect on a website with an avatar. That avatar could be personal data. The way if you have a special way of walking, the way you walk may identify you, and that could be personal data as well. Your DNA certainly is personal data. Your health information is personal data, and so on. So it's a wide scope of things here. Now, Singto, in the article, what are the requirements when you've identified personal data under the law?
Can you rephrase your question?
Sure. Under the data protection law, what are your requirements once you've found that there's personal data?
Requirements for who?
Well, we talk about a couple parties here. We talk about a controller.
Okay.
We talk about a processor.
Okay, so for them, when there's personal data involved, they have like an obligation to protect it.
When you say protected, what do you mean?
I mean, they have to implement security policies to ensure that the personal data of maybe their customers is not used for any other reason outside what the customer allows and what they say they're going to use it for.
In other words, we've got a purpose limitation. Okay, what else can you discuss here?
Sometimes maybe if it's it can, I think the states or maybe a nation, yes, the states can access personal data for national use or something.
Okay. Now, the data protection legislation that I talk about in this article is with respect to commercial access to data, commercial use of data. And that commercial data, if it's the personal data of someone inside the EU, that data, when it's processed, will be subject to the provisions of the European Union Data Protection Law. What does processing mean, Singto?
Processing is, how I put it, I can't think of a word right now, but
Okay, let me help you here because this is a large article that you read, and there are lots of aspects to it. Processing involves many kinds of operations you may affect with respect to data. It could be the collecting of the data, the saving of the data, the storing of the data, the analyzing of the data. Thank you. What else? Why don't please continue? What else could it be?
So it is something like when you perform certain operations on the data, it is called as the processing of it. It may be in the terms of let's say a certain set of instructions or formulas or the tactics for collecting or analyzing the part, or it may be something just like the.
Go ahead.
I'm finished with the words actually.
It could be, let's take another example. And I think I mentioned it maybe in the article in terms of did you go by Kumar? Okay, so Mayank Kumar, let's take the example of Google. And let Mayank Kumar, when Google, what do they do with data? For their search engine?
They are analyzing your daily habits or daily searching keywords. So on the basis of that, they are just giving you the certain predictions, or let's say they are aligning your search, or they are making the process of searching smooth for you. Just like, for example, a day before, if you have searched for certain articles, let's say, for example, then they will again, on the very next day, they will again highlighting, or let's say giving the suggestions for related to that particular one.
Okay, Mayank Kumar, but what the first thing they're doing is probably searching the web with a bot and indexing the data in order to be able to serve it back up to people. And certainly they're analyzing it to determine what data to serve back to you. But that is processing of data as well. So if you have an individual who's alive, because this law doesn't cover dead persons, if you have an individual who's alive, located in the European Union, they don't have to be European Union citizens. Their personal data is being processed, then there's coverage of this law. Now, who can tell me who's a controller? What's a controller? A data controller or controller. Well, a controller is the party that determines what data will be collected and how it will be used. And normally, they are the ones who will determine what the next step is, how it will be processed, and who will process it. And then they can go to third parties, processors, for assistance in processing that data through a contract and dividing up certain responsibilities in a contract. Now, for example, I could be Air France. I have my website. My website, when I go onto my Air France website, I see this site uses cookies. Those cookies, what are they?
They are accepting your consent for processing the data.
Yeah, but what does a cookie do?
Keep your preferences.
Okay.
It registers the fact that you've been in this website and.
Right, it can follow you through your navigating.
All the preferences you put, all the clicks you made it.
It's kind of an ID card from you to this website and.
So we would consider under this law that what it's collecting is personal data. It's data about you. It could be data about you and your preferences. It could be data about you and your navigation, what you do, where you go on the website, etc. Now, Air France then is determining what personal data to collect and how to collect it. So it would be a controller. Now let's say that Air France engages a cloud service provider to store all this data. That cloud service provider is usually considered a processor of the data. Now, both can have responsibilities under the law. Traditionally, we have thought of the controller as having the majority of responsibilities, but both under the GDPR can have responsibilities under the law. And we hope, I don't know, did anyone hear about OVH today? It's a large French web hoster.
Oh, yeah, the burns.
Yeah, that burned down in Strasbourg. Hope your cloud service provider is not OVH in this case, with their Strasbourg servers. Okay, but let's take this back to aviation. What happened in the cases with British Airways in this article?
Someone has breached the data and council has fined British Airways for, I think, pound or anything.
I think it was 20 million pounds fine, the eventual fine. Although the first notice that the Data Protection Authority, the supervisory authority of the United Kingdom, ICO, the first fine that they proposed was 180 million or so pounds, which is quite a large amount of money when you think about it. It was about 1.5% of the turnover of British Airways. They can go up, in the case of the most serious types of offenses, up to 4% of annual turnover in terms of a fine. If it's a company, 20 million, the higher of 20 million euros, or 4% of annual turnover. Now, in order to process data, what do you need? What is the legal prerequisite? What's a legal grounds that you need to process data?
Consent?
Consent is one of 6. Consent is one of 6 potential legitimate bases. So you need a legitimate basis to process data. Who just answered me? Emiliano?
Yes. Yes, Emiliano. It's Emiliano.
Emiliano. Okay. What are some of the requirements for this consent?
I don't have any idea. Sorry.
Okay. It has to be informed consent. In other words,
yes, it has to be explicit consent or very confirmed.
And it has to be, you have to have it identifiable, separate from other matters, and so on. So it has to be very clear to the data subject. The data subject is the person to whom the data relates. Okay, let me think of what some other important things are. What is this Schrems 2 case about? Who can tell me about this Schrems 2 case?
I have one question regarding British Airways.
Yeah.
What would be the next step regarding the Brexit?
Okay. Regarding Brexit, what happens is until the end of 2020, there was a transition period. And so the law in Great Britain was the GDPR. Now we're in another period where it still is British law, but it becomes the UK GDPR in Great Britain, in the United Kingdom. And today, the British can modify the GDPR according to their own wishes. Now, for 6 months, there's under the UK European Union free trade agreement that was negotiated in December, they've extended the period for treating Great Britain as having an adequate level of protection of data. They've, well, maybe I should write it here. So until July 1 or June 30th, they're at the latest, they've extended the time period during which it will be considered that the British have an adequate level of protection of data to allow for free flows of data between the European Union and the United Kingdom. But after that date, there needs to be a determination that they have an adequate level of protection or some other basis in order to export data to the United Kingdom. But they'll have their own law. But for the reasons of this adequacy, they have an interest in keeping it similar to the European Union law. Now, the European Commission has tentatively determined that the United Kingdom offers an adequate level of protection. This adequate level of protection is necessary under the GDPR in order to export data to a country outside personal data of EU persons outside of the European Union. If the United Kingdom gets this adequacy determination, gets this adequacy decision, which is a decision of the European Commission after consulting with some other institutions. If they get it, there can be this free flow of data. But the decision is reviewable periodically. So they have to keep up their protection of data in order to benefit from this decision. So that, in short, is the story about Brexit today. Now, so they still have a GDPR, but it's the UK GDPR. Excuse me. Now, in a nutshell, this Schrems 2 case was brought by Maximilian Schrems. Maximilian Schrems was an Austrian law student who was interested in internet, went for a semester or a year abroad in Silicon Valley, and he originally said to Facebook, I'm exercising my right because under the GDPR, data subjects have rights. They have a right of access to their data, a right to correction of their data, a right to object to the processing of their data, a right to erasure of data when it's obsolete or no longer necessary for the purposes for which it was collected and processed, a right to data portability, to get it in a transposable form, a common format, and transfer it to someone else. Well, this was before the GDPR, under the 1995 directive. Schrems initially said to Facebook, I want access to my data, and got a huge PDF file with thousands of pages in it, because Facebook collects everything on you, everything you do. So he went to the Irish authorities, where at that time, the main Facebook office in Europe was located, and said, my data isn't being protected because Facebook is sending it to the United States, and the United States may share it with the authorities for mass surveillance purposes, following the Edward Snowden disclosures. So this went up through the court system, and there was an agreement called the Safe Harbor between Europe and the United States, which allowed for the export of data to the United States, because the United States was not considered to have adequacy in terms of data protection. Safe Harbor was only one of the methods of being able to export data. There were also binding corporate rules BCRs, standard contractual clauses. Which could also be used, SCCs. The binding corporate rules are usually between a parent company and a subsidiary, or a parent between two affiliates in the same corporate group. The standard contractual clauses are often used between processors or between controllers and processors that aren't in the same group. So these two exist, but the court in Schrems 1 invalidated the safe harbor. And the safe harbor then was replaced by what was called the privacy shield. Now, this privacy shield was an agreement like the safe harbor intended to give protections to data subjects when their data was exported to the United States, giving them more or less the same set of rights that they have when under European Union law. And Schrems brought the Schrems 2 case not to aim at privacy shield, but to aim at standard contractual clauses, claiming that companies receiving the data in the United States couldn't respect the terms of the standard contractual clauses, and so they should be invalidated. Well, the European Court of Justice, the highest European Union court, decided on their own to invalidate the privacy shield. However, they allowed standard contractual clauses to stand, so long as you could meet the requirements contained in the contracts clauses as they stood. And that involves an analysis, at least for the United States, that I set out in the article. That is, it probably works for airlines, which I mentioned in the article, but it has to be looked at, investigated on a case-by-case basis. See if you can comply with the protections in the standard contractual clauses under the law of the country that's the importing country. So again, standard contractual clauses can be used to go to China, export data to China. If you can legally, if the Chinese legal system will allow you to respect the contractual terms. And you have to do a legal analysis of that. Same with sending data to Russia or to Brazil or to South Africa or to other countries that are not yet considered to have an adequate level of data protection. Okay, those are some of the main points in this article. And you can see I've looked at what the US airlines were using as a basis for exporting that data. And most of them were using standard contractual clauses. Now, I would like us to do an exercise. And I'm going to divide you up into groups to do this exercise. This is a case. It's, it's too many cases that I would like you to work on right now. And they're on cases related to personal data or data protection on campus. So I will divide you into groups on Zoom. So I want you all, those of you in this room, to be on Zoom right now. And I'm going to give you some time to work on this in group and then present the results of your work. So let me divide you up into groups, and I will surf between the groups, be available to the groups if you have questions. Yes?
Can we work together? Because otherwise, let's see if we're all connecting at the same time.
Then I'm not able to use Zoom to.
Yeah, I think you can modify the users in each team.
But just to avoid that, if we're connecting all together at the same time,
We're gonna have to go in different groups.
Data from European Union persons,
Yes.
and they're doing this to offer goods or services to them?
Yes, exactly.
Okay, so in this case, they would be subject to the GDPR, and if they don't have an establishment in the European Union, they must have established a representative in the European Union. Good. Okay, question number 2. I would like someone in this room to volunteer. One of the people present, one of the 2 groups present. Do I have a volunteer?
So,
Don't be shy.
the first obligation is they are not allowing the management of cookies on the browser, so they are under Article 7, under the conditions for consent. And they are also under Article 13 for the information to be provided where personal data collected for the data subject. So they are also not having data management, so user is not having where the data is going to, store. So whosoever is having the breach, they cannot have the access to that also.
Okay, this question I more or less played around with the facts of the Vueling case. And so the idea here is that you've got to have the proper information and you have to have control. So here, do they have control over whether or not?
No, they are not having control.
So here you're saying that it's not meeting the requirements for cookies. Now, you'll notice that I put in your article, I put a selection from an extract from another law called the e-privacy directive, which was then transposed or implemented in national European Union law. That law is subject to a reform, discussions about a reform, which may end up in a regulation being adopted, which would be potentially much larger in that it would cover not only electronic communication sector, but also over the top OTT services, which include WhatsApp, all these other kinds of services that you use instead of the telephone today. Now, that was amended, the e-privacy directive was amended in 2009, and it added information requirements about cookies. That's why we have cookie banners today. However, if you're looking at the requirements for consent and the requirements required to consent to cookies, that's in the GDPR. Okay, good. Let's have someone from room 2, salle 2, answer question number 3. Room 2, please.
It might be us, but we are not.
Okay, give it a try.
I'm connecting my computer because I'm running out of battery. Alex, can you speak to that one, the third one? Sorry, he got kicked out of Zoom.
What's that?
No. What a bad moment.
No, because he's going to know that we are
Okay, why don't I go to another group?
Yeah, Professor?
Yes.
Sorry.
Yes?
Yes, I am here. Sorry, Professor. Is that at the very same moment? At the very same moment, my computer was dying and I had to connect urgently to the...
Okay, let me try another group. Let's have the other group that's present here, your group. Number 3, please.
The question. Okay, we are struggling because we have written everything in the chat, in the group chat, and actually it has all been removed once we have been kicked out of the chat. So now we have to
Sorry about that.
look again. But I think if I'm not wrong, no, can we reply to the question 4, which I
Yes.
remember by heart?
Yes, go ahead, answer question 4.
Okay.
And you group, you will do 3, huh?
Okay, thank you so much.
But
Because
go ahead and do 4 right now.
okay, thank you, Professor. Because since it's the last one that we have done, is the only that we have memorized by heart.
Okay, go ahead. Go ahead.
Okay,
Number 4.
so what we think with respect to what recommendations will we make to our employer in the future? We have gone to the responsibilities that a company should have as a controller. So we have gone to the Article 24. Well, we, as a conclusion, we have stemmed the 3 only points that are in this article. So implementing the appropriate technical and organizational measures, and well, proportionating the proper processing activities, and
Well, for the technical measures, you might want to have a complete answer. Talk about encryption, talk about pseudonymization, etc.
Do you want us to dive deeper into that?
No, I'm saying I'm completing your answer.
Okay, that's it. Yeah.
But continue, please.
Okay. And the third one that is adhering and approve, the approved codes and conduct as referred to the Article 40, etc. That actually is what we were completing just now.
Okay.
Yeah,
Now-
definitely the company has to be assessed by an appropriate cybersecurity external company that can adjust their web operation and their web loopholes that might be present in order for them to be able to accomplish the GDPR. Otherwise, they will be breached constantly.
So your recommendation would be to have them be audited.
And constantly audited, yes, not just once in order to implement it, but they need to implement a constant audit system so that they are constantly, like, internally tried to breach, so that they are constantly trying to see which loopholes are there present, so they always know
And one thing a company can do, if you're anticipating new kinds of processing, you can perform an impact assessment, a data protection impact assessment. And I've seen many professionals recommend that, for example, when the Schrems 2 decision came with respect to data exports, having people have this auditing going on. So that's an interesting answer. The other path you could have discussed is whether or not they wanted to direct themselves to EU persons, because there are ways of avoiding targeting EU persons that are discussed in the article. So I refer you back to the article on how you can be considered not to be targeting EU persons. Thank you very much. Let's have a group in this room do question 3, please. Gerardo.
Yeah. When it comes to question number 3 regarding the liability, if there is in any case with respect to the surveillance and placement of cookies, we have to say that the responsibility for the controller, we based our answer in the article number 24, which says the controller shall implement appropriate technical organizational measures.
Yeah.
Ensures and to be able to demonstrate that processing is performed in accordance with this regulation. But these measures will be reviewed and updated if necessary. And also that the controller shall include the implementation of appropriate data protection policies by them, plus adherence to approved codes of conduct or approved certification mechanism.
Okay, so you could use approved certification mechanisms, codes of conduct. Those are other things that can help improve your situation, prove your compliance with the GDPR. Now, remember, this GDPR is based on accountability and being able to prove compliance at any time. So you need to develop records of proof of how you're complying with the GDPR and have those available in case any supervisory authority audits you or asks you for this kind of proof. Good. I would like a volunteer from those connecting distantly for the CETA questions. Please, anyone from a distance. CETA. Let me call on someone then. How about Alwyn? My star from Sesames.
Sorry, Professor, but I was working with Group 1 on the first case. We were not able to finish or move into the second case.
Okay, I'm going to go to another star from the Sesames who's present in this room, and that's Charles. Because Charles asked a question already about this at the beginning. So I think he understands some of the issues involved. So please, Charles, would you answer for us? Remember we were talking about what information, additional information you needed?
Yeah, I was wondering what was exactly CETA compared to and what was the role of CETA compared to the airlines? Is it the company that is supposed to gather the information, the data that companies are collecting from their website? So in my opinion, yes. So they may have the potential liability for the breach they suffered last month. But since it's a company that is based in Switzerland, they may not be under the GDP. However, since it's dealing with data coming from airlines that are European or that are collecting data from European citizens, I think that we can consider that they have to comply with this regulation. And yeah, what information do we need to and that's it. Yeah, maybe they to reinforce their security, they would maybe have to do the same as the previous case.
Okay, similar security measures as the previous case. Xanthia?
The difference here is that they in the article they mentioned that they communicate the reason, not the reason, but what kind of information breached to the airlines and to the travelers, I believe.
Yeah, the data subjects.
Yeah. So they explain that they only the member, the status and the names of the passenger have leaked. They say that passwords and payments information they remain safe. So they follow the I don't remember what article it is, but they follow the regulation regarding that point.
Okay, now here we don't really have enough information. We need more information to figure out the role of CETA. Are they a processor or are they a controller? Now it would seem that they're probably a controller, but we're not sure. So we need more information. Processor, sorry, that they're working for the other airlines who are the controllers, who get the data and then have CETA perform services for them, but we're not sure of that. And that plays a role in our answer. It's true, CETA is Swiss. Switzerland has similar data protection law to the European Union. Although they are not subject, Switzerland does not impose the GDPR. So in order for the GDPR to apply, it would need to apply because of the offer of goods or services to persons in the European Union, or CETA would need to have an establishment in the European Union in order to be subject to the GDPR. Now, just for your information, the GDPR applies in the EU. We have the UK GDPR since Brexit, but the GDPR also applies in the other European Economic Area countries, which include Norway, Iceland, Liechtenstein. That may be it, I forget. Okay, so we've got the European Economic Area, but Switzerland isn't joining the GDPR as part of the EEA, but they have legislation similar to the GDPR in Switzerland. Okay, so but we needed more information. Now, I just circled CETA because CETA plays another role in what we're going to be discussing later in our class, and that is I believe they were co-runners of the international registry under the Cape Town Convention that we'll discuss in a few minutes. Okay, please stay with me. I want to quickly go through the rest of this PowerPoint, and then we're going to do a group activity. We have till 5:30. Okay, good. Okay, I'm going to now lecture about a little bit about transactions. And I'm going to remind you of a few provisions of contract law because we're going to be looking at a sales agreement, an aircraft sales agreement. I'm also briefly going to talk about leasing and financing. Okay, as you all remember from your first year here at TBS, a contract is a meeting of the minds in accordance of will between the different parties. It's almost like a private law that exists between the parties that agree to the contract. And to have a valid contract, you need a consent of the parties, their capacity to contract, and content which is lawful and certain. Now, just a few points about this in the aviation context. We're talking about an aircraft agreement. Many times when it's signed to determine the consent of the parties, we have the signing, but we also have to look at the capacity to contract. In France, for example, companies have legal personality, which gives them this capacity to contract when they're listed on the companies and commercial register. And usually it's the setting up, the filing of corporate documents that triggers the existence of this corporate personality, this legal personality that allows someone to contract. But in order for a company to contract, they have to have someone, a physical person, a natural person, like one of us in the room, do so on their behalf. So they would need to consent usually through agreeing to contract terms and having this agreement done by someone who has the power to do so within the company. For example, if it involves a financing, maybe the treasurer of the company has the power to sign credit agreements involving financings. And usually you need to provide proof at the time of the signing of the documents. For example, have corporate resolutions where you've approved the transaction, and have maybe a secretary certificate confirming the signature of the person who's going to be signing. The general principle we know is contractual freedom. However, there are some limitations on this contractual freedom, which in France include public policy and good faith. Now, France has good faith as a requirement, not only for the performance of contracts, but for the negotiation of contracts, the entering into contracts, and that's in the Civil Code. Not all nations have the requirement that you have good faith in negotiations. For example, India does not. The United States, if you go to New York does not. So if you want to require people to negotiate in good faith, you have to enter into some kind of contract which binds them to negotiate in good faith. Maybe it also will have provisions about an exclusive negotiation period, okay? But that's something you have to investigate in the law that's applicable to your transaction. There's generally no form of contract required, but you must have a contract lawfully entered into. Now, there are some exceptions to this contractual freedom about forms of contracts. And authenticated acts, like mortgages and certain other agreements like pledges in France, need to take a certain form. This is usually because of public policy concerns about being certain who owns something at a certain period of time. Now, with aviation, this could be true in financings, where you may have to have an authenticated act to, for example, give a mortgage on an aircraft, or to give a mortgage on a aircraft engine that's being financed. So the financing parties who are getting this may have to have the form of their document as an authenticated act signed before a notary. Maybe there's a tax involved, a payment of a tax to the authorities. Now, even though there's this freedom, industry standard agreements may exist. Now, there is documentation, standardization, and simplification in the aviation industry. This is considered to bring advantages in decreasing negotiating time, reducing transaction expenses, increasing efficiencies, and in deciding whether or not to standardize contracts, you can think about the forms of your existing documents, the processes during which they're negotiated, and the nature of any particular transaction to which you must tailor the documents. Now, there are two groups that one I've already mentioned, that is the IATA. They have worked with the Aircraft Working Group, which is a group that I worked a little with when I was in the aviation industry. They were initially set up to work on the Cape Town Convention, the proposal of the Cape Town Convention. And they started working on standardized and templated documents for aviation transactions under New York or English law. In preparing for this class, I looked back at the Aviation Working Group website, which is here, AWG Aero. And I saw they no longer have contracts, templates on their website. However, I noticed that IATA does. So if you go to the IATA website, they have certain agreements. Maybe there'll be templates for mortgages or other documents which are available on their website. They're not required to do this. This is an area of contractual freedom, but they're recognizing their potential benefits of standardization. There's nothing in the law that requires you to use those. However, they're available, and there's an impact. For example, you may find that changes in a Boeing contract may influence Airbus and their contract, or vice versa. So even though you're not required to have standardized agreements, this happens as a practical matter in business. Now, we talked in our last class briefly about force majeure. And force majeure is a point that you'll probably look at in these aviation agreements. Usually in an aircraft purchase and sale agreement, you will have force majeure taken into account in what is called excusable delay or inexcusable or unexcusable, non-excusable delay. In other words, if force majeure applies, it can excuse non-performance under the agreement. For example, if an aircraft manufacturer is unable to deliver an aircraft on time, if there's a case of excusable force majeure, then there will be no penalties assessed in terms of the manufacturer. Now, in order for force majeure to apply, and we do use this term in English, in order for force majeure to apply, we need to have an event which could not reasonably been foreseen at the time that the contract was concluded, and whose effect could not be avoided by appropriate measures, which prevents performance. Typically in France, we talk about three conditions: unforeseeability, unavoidability, and something being external or beyond the debtor's control. Now, I've heard in negotiations, people try to negotiate what is considered force majeure or not. And for example, there may be some discussions about what happens if there's a strike, a work shutdown. Well, if it's just in your company, maybe it's not exterior, maybe it's not external, maybe it's not beyond your control. Maybe it's something you could have handled inside. But if it's a surprise nationwide strike, then it's more likely to be seen as a case of force majeure. Now, this concept of force majeure also usually includes what we call natural disasters. May cover war, may cover civil unrest, and so on. But you have to look at how it's interpreted under the law that applies to your contract. And usually that involves looking at cases that have been decided. Now, in terms of leasing and financing, we have different kinds of leasing, different kinds of financing. First of all, if we look at leasing, we have operating leases, where there's no element of finance involved. In an operating lease, these are arrangements where the lessor, who is the owner of the aircraft, will be required at the end of the time period of the lease to take the aircraft back. And there's no transfer of ownership to the aircraft. A finance lease is different. A finance lease is a financial device where rent payments over the life of the lease will be calculated so that they will permit a purchasing of the asset, the aircraft, for example, over the term of the lease. In other words, where if all the lease payments are made, at the end, there'll be a transfer of ownership over to the lessee. In other words, the reversionary interest in the aircraft will be transferred to the lessee, the tenant, the lessee, during the term of the lease. Now, there's something interesting about this legally, and that is the lessor retains ownership until that last lease payment is made. And that is the best kind of security of all, title, ownership, in terms of being able to get the aircraft back. Something not good happens, there's some non-compliance with the lease agreement. Now, a leverage lease is a lease involving at least three parties, where usually you have the lessor borrowing most of the funds needed to acquire the asset. It could be aircraft, financed by a third party, and the lessor gives a mortgage over the aircraft and assigns the lease rentals to the financing party. This may benefit from tax reductions, depreciation, loan interest reductions.
And what kind of companies are generally the creditors?
The creditors could be banks, or could be credit companies. Now, I've seen, you have to look and see what the market is for these leverage leases, because these leverage leases over time, they're like flavors of ice cream. They change with time. When I was a younger lawyer, I talk about ice cream, I was involved in what were called double dip. That sounds like an ice cream cone. Double dip leverage leases. And they were called double dip leverage leases because they were structured in a way that they received tax benefits in two countries, which lowers transaction costs. And they were able to do that because of the definition of ownership in tax codes for tax purposes. For example, certain tax systems are based on a concept of ownership that is economic, where others are strictly legal. And you may find two jurisdictions which treat it differently, which allow someone different to be considered as owner and allows someone different to be able to benefit from amortization and the reduction of tax exposure based on tax benefits for the amortizing the asset. So I was involved in different ones. There are different periods where Japanese leverage leases have been popular, or Chinese leverage leases. It usually depends on not only the legal system, including the tax law of the jurisdictions, but also which a country has the financing available for, and the taste for this kind of transaction available. So there's an old book that I have a copy of personally, but it's in the library as well, which is actually quite good. It's old now. It's over 20 years old, but it's called Aircraft Financing. And I worked with many of these people who wrote these chapters. They set out industry financing requirements, sources of finance, financing methods, and they talk about leverage leases in this. And they set out, for example, structures and financing with little charts where you have, for example, as parties, you may have export credit agencies from different nations if you're an exporter coming from that nation. So here they have the European, this is an Airbus transaction where they have the European export credit agencies, the COFAS in France, Hermes in Germany, and ECGD in Export Credit Guarantees Department in the United Kingdom. And they're coming together with a special purpose company set up for the transaction located in, well, maybe today we wouldn't see this, but in this example, it was set up in a tax haven, paradis fiscal, a tax haven, the Cayman Islands, to reduce tax exposure as well. Here we have a Japanese leverage lease set out where you have equity, a security trustee, a senior lender, junior lenders, the Export-Import Bank coming into it and so on. So you have different structures involved depending on the kind of leverage lease that you are doing. But the idea is that the leverage here is intended to reduce transaction costs, that it is allowing for tax deductions for depreciation, amortization, and loan interest. And those lower the cost for the airline and benefit the finance parties as well. Now, in France, we have the legal structure of the crédit bail, which is a kind of finance lease. Here, there's a purchase option, and it's treated, this kind of transaction is treated as a credit operation, thus as a banking operation. If it's entered into more than on a, more than on a one-off basis. So if you're engaging in this kind of transaction on more than a one-off basis, you need to be a credit establishment, licensed as a credit establishment, regulated as a credit establishment. Now, just from my experience, many finance parties don't like this aspect of the French law. So they'll seek to finance aircraft instead in the markets of London or New York. But it's totally possible to use this French structure to finance aircraft in France. So here we'll have equipment, usually large elements of equipment or machine tooling. That will be the subject of the crédit bail. Aircraft is a large element of equipment that could be financed by a crédit bail. And at the end, there may be a balloon payment, a last rental payment. It may be larger than the previous ones, which will give the lessee the possibility to buy the asset at the end of the lease. Now, this usually involves the manufacturer and their eventual customer, for example, an airline, who have identified the what they want to buy from the aircraft manufacturer, but then we'll have the financing party, the lessor, the buyer, who will be providing the finance in the transaction and actually purchasing from the manufacturer and then leasing back to the airline, putting this on the lease to the airline. So even though the airline will initially have entered into a purchase agreement, they will transfer that purchase agreement. They will assign it over to the lessor, the kind of credit establishment. If they're doing this more than on a one-off basis, who will purchase and then put it at the disposition of the airline. Again, the lessor will retain ownership until that last rental payment is made. And that, again, is a kind of security. For example, if the airline doesn't perform, the lessor may want to repossess the aircraft. In order to do that, you've got to go to a court and get a court order that allows you to repossess the aircraft. Proving that you have ownership is the best kind of proof you can have in this circumstance. Because then clearly, if there's a non-performance under the agreement, you should be able to get the asset back.
And who was the liability of the aircraft when it's leased?
When it's leased, the liability, what's the word we use in legal English? The risk, the burden of risk will be held by the lessee, the airline. Okay, so the airline will have to ensure that the aircraft will have to be subject to maintenance requirements, will be subject to operational restrictions and so on, because these are all important in maintaining the value of the aircraft, which is still the property of the lessor. So the lessor wants that property to be maintained. Okay. Now, the Cape Town Convention, and again, I saw this from the inside. It was quite a nice experience because I worked with the Aviation Working Group, which is formed by aircraft manufacturers, engine manufacturers, leasing companies, financing companies, banks. And we went on this. We drew up a proposal for this. We worked with UNIDROIT, which sponsors international conventions. We lobbied for it. I remember going up to the French Ministry of the Economy on this and trying to convince them that even though it might seem a little Anglo-Saxon, a civil law country like France should still be interested in this. And we went to the European Commission and lobbied on this. And there even was a meeting with the United Nations and so on. But eventually it was adopted. It's still going through the ratification processes. There are countries, more and more countries signing on to it. I just checked, and I don't think France has signed it yet. The United States has. Lots of other countries have. I think Brazil recently did. But the idea here is to protect those international interests in mobile equipment. There is and to be honest, the real emphasis here was to protect interests like mortgages, like leases, to protect them in countries which don't have perhaps the same rule of law circumstances as we have here in Europe. In other words, where there's not the same confidence in their legal system as we have here in Europe. It creates international standards for registration of contracts of sale, security interests, leases, conditional sale agreements. Helps ensure enforceability of financing arrangements, provides for remedies if there's default, and includes self-help remedies that are allowed by contract. It set up this international registry, which I believe is organized by CETA with the Irish government. I think they created a joint venture company which got the award for this registry. You've got a link for the registry here. It's supplemented by protocols which bring certain kinds of equipment under the convention. For example, there are protocols for aircraft equipment, but also for space equipment assets, rail equipment, and MAC, what is this again? A is agricultural. I forget what the M and the C are. Anyway, if you look up this site on UNIDROIT, you'll find that. You find the different protocols. Now, not all of the protocols have had enough ratifications yet for them to come into effect. So you've got to look and see, has this protocol come into effect? So they provide specific rules for specific types of assets, equipment. Now, under our chapter on buying and selling, sellers required to explain clearly their undertaking. And under contract law, any ambiguity in the contract is interpreted against the seller. So we can see this as one possible reason why the seller usually likes to use their standard contract and control the drafting of that contract, because they don't want to be in a situation where they have ambiguity in the document, which will be interpreted against them. So in aircraft, Airbus will have its standard contract. Boeing will have its standard contract. They will want to have the responsibility for writing the contract itself over negotiations. Now,
Sir, excuse me.
yes, go ahead.
Could you give an example of an ambiguity? Because I have a hard time understanding this part.
Ambiguity, where it's not clear whose responsibility something is. If there's an ambiguity about who's responsible for the, let's say it's not clear when the risk of loss passes. Well, then, if it's unclear in the contract, it will be the burden of the seller, this risk of loss. That's probably not a good example. If there's, let's say it's not clear how a price index works, it will be interpreted in a way that's least favorable to the seller in that case, because it's the seller's obligation to write the contract well.
Okay, thank you. It's clear.
And there's always potentially ambiguity, especially if you're dealing with people from different nations where you've got different languages, different language versions of a contract being created. Okay, this is just something you remember. Expenses of delivery are usually for the seller. The obligation to deliver is one of the essential obligations of the seller. If you don't specify the place of delivery, it's at the place where the goods are at the time of sale. Often we use Incoterms, trade terms, Incoterms, to indicate where the sale will take place. And the seller, their second major obligation is to warrant the goods against dispossession and against hidden or latent defects. Also, buyer will have remedies for failure to deliver or late delivery if there's no force majeure. And this may allow them to seek cancellation of the contract. The buyer, on the other hand, is required to take away the asset that's being sold. If it's not removed at the agreed date, there may be a cancellation of the sale. The other major obligation of the buyer is to pay the price on the day and at the place set out in the sales agreement. If you don't set anything else out in the contract, it's at the time and place of the delivery. Here in France, you would want a clear statement in writing that the seller keeps the ownership until the purchase price is paid. In other words, it's a retention of title clause that says the seller retains title until the full purchase price is paid. Notice that on air transactions, we often have pre-delivery payments because it takes so long to build an aircraft. The aircraft manufacturer will want to have some of the money up front. Now, in France, there's often a debate. If if you pay money up front, is it earnest money or is it a initial payment or a payment on account? The terms used in French for these are acompte for this and art for this. The legal importance of this is that the initial payment means that the parties have recognized that they're in the transaction, that they're bound by the transaction. And if they don't fulfill their obligation to perform, they will lose this initial payment, this payment on account. Now, the earnest money is money that will be paid. It's money that will be paid to show that you're earnestly entering into the transaction. And that you have the ability to make these payments. And if one of the parties defaults, they can get out of the transaction. However, the treatment depends on who is trying to leave the contract, who's not complying with the contract, who wants to leave the contract. If it's the person who paid them, the payer of the earnest money, they will lose the earnest money. If it's the person who's received the money, so let's say the payee. If it's the party that's received the money, they will have to give back twice the amount that they received, double. This is covered by, this case in the French Civil Code is covered by Civil Code Article 1590. So it says in French that si la promesse de vendre a été faite avec des arts, chacun des contractants est maître de s'en départir. Celui qui les a donnés en les perdant, celui qui les a reçus en restituant le double. So you have to give back. You lose if you're the payer and you choose to leave the contract. If you're the payee, you have to return twice the amount. Okay. Now, I think you know about the Vienna Convention. It is a convention which provides for rules on the international sale of goods. It can take the place of a nation's law. You always want in your contract to state which law applies to your contract. You've got the power, the liberty to choose the law that applies to your contract. If you don't make a choice, a court will look to principles of international law, a body of law called conflicts of law, which you don't really want because you don't have certainty about what law will apply then. Because knowing what law will apply lets you know what the obligations of each party will be and what the potential remedies are. In Europe, we have today the Rome I regulation, which sets out whose law will apply if you don't pick a choice of law. It allows, in its Article 4, for you to pick a choice of law. If you don't choose, it sets out criteria for establishing whose law applies. For a purchase contract, for example, that will be the seller's law, the law of the place where the seller is domiciled, which will most likely apply there. Okay, we're, I think, almost up to our activity. So the Vienna Convention is one choice of law that you can have. It's widely, well, 94 nations. It applies automatically if you meet three tests. If you meet three tests, that is between parties with places of business in different states, that and either the parties' place of business are in contracting party states, or a conflict of law rule would lead to application of the laws of a contracting state. When I say contracting state, I mean a member to the Vienna Convention. But it excludes aircraft sales. However, it might not exclude aircraft parts sales. It doesn't say anything today, I don't think, on drones. I have to think that drones would be considered aircraft. But I don't have in the language of the convention anything to tell me that. And you can choose to opt out of the Vienna Convention. The CISG, Convention on the International Sale of Goods, Contracts for the International Sale of Goods, Vienna Convention. So you can opt out by putting language in your contract. The sales contract is governed by the domestic law. There you're excluding international law. Or it's governed by the national law of a certain country and exclusion of the Vienna Convention. Or this is an example from an Airbus contract when Airbus wasn't yet an SAS. The parties also agree that the United Nations Convention on Contracts for the International Sale of Goods will not apply to this transaction. That's meant to exclude the Vienna Convention. This is an example of an intellectual property indemnity. I'm going to skip over that. You can read this on your own. It'll make things go quicker. I'm going to perhaps make larger groups. Okay, let me divide you into groups now. Any questions before I divide you into groups? And we'll try to intervene in 20 minutes at 15 past. Any questions before I divide you into groups? Okay, do as much as you can. Yes.
Can you just repeat the 5 names?